Welcome to Law and Life, the Leverance Approach.
Welcome back to Law and Life, the Leverance Approach with attorney Yoni Levoritz. Yoni is the founder of Leverance Law Firm and is recognized for his exceptional skill in family law, his compassionate manner, and his commitment to achieving favorable outcomes for his clients. I'm Kevin Rosenquist, and today's episode is all about appeals in New York family law and the circumstances that lead someone to challenge a trial court's decision. Yoni, welcome back.
Thank you for having me, Kevin. Good to see you.
You as well. So in family law, what typically prompts a party to consider an appeal rather than accepting the trial court's decision?
Being unhappy.
Oh, all right.
You get the order, you look at it, and you say, wow, I lost. Or, wow, I didn't get something I should have. Or, wow, the trial court made a mistake. You know, it happens with child support or alimony, or as it's called legally, maintenance. Trial courts make mistakes in math. You know, lawyers are not mathematicians. Mm-hmm. We became lawyers to avoid math, and then all of a sudden they throw math at you. So it's a problem.
Yeah, I don't have to do math either, and that's by design. That's by design.
Yes.
So how do you help a client decide whether they're just disagreeing with an outcome or they actually have legal grounds to appeal it?
When you look at the actual testimony, or you look at the record, or you look at the motions that were filed, you could figure out if a court made a mistake. You can figure out, you know, exactly what the story is and try and figure out, did the court abuse its discretion in terms of the testimony that was elicited? Hypothetical, you know, you go for a child support hearing, or you go for child support in Supreme Court, and they come back and they impute income to you, meaning they add income to your income based upon what you're capable of earning, because child support is based upon capacity, not based upon current economic circumstances. Mm-hmm. So you have a situation where they go ahead and they impute to you $200,000 in income. You're only earning $120,000 in income. That's an $80,000 imputation. Did the court have a basis? Did it have a logical rationale for going ahead and saying this is what it is in terms of the $80,000? Was it based upon education? Was it based upon training? Was it based upon past income? If it was based upon past income, was there a change that caused the income to go down? I mean, if your job was replaced by AI, I mean, is it really your fault?
Mm-hmm. Mm-hmm. And the courts actually have to consider this.
The courts have to consider all of them. You just got hit with an extra $80,000 on your income. Right. If you've got two kids, that's 25% of $80,000, basically.
Mm-hmm. Yeah. Yeah.
That's a lot of money.
It is.
Just imagine having a 5-year-old that you're going to be paying $300,000 extra for till their age of 21, okay, or spending, you know, $50,000 on an appeal where you're probably going to be able to get your income lowered back to your 120 because, you know, AI has taken over part of your job. Right.
Yeah. So you did math. Look at you.
Well, once in a while when it's round, easy numbers.
Okay. Gotcha. So when you review a case for a potential appeal, what parts of the record or ruling tend to be the most critical to examine first?
It depends upon the case. If we're dealing with the custody case, it's very difficult to do anything without reading the entire transcript because it's all based upon credibility. A lot of custody cases are he said, she said, backed up by some text messages, backed up by some emails, backed up by some videos. Did the evidence support what the court found? Okay, because sometimes courts just go ahead and they don't like certain people. Mm-hmm. You know, courts like everybody else, they don't like the man, they don't like the woman, they don't like their story. You know, someone cries but no tears come out. You know, things happen. What exactly drove the judge to their decision? And then you're looking at an abuse of discretion issue. And then sometimes when you're dealing with economic issues, they're more legal in nature. Okay. For example, you had two experts testify. You had the expert one testify, piece of artwork is worth $1 million. You had expert two testify it was worth $800,000. Which expert did the court accept? Why did they accept them? What made one expert more credible than the other? Did the court abuse its discretion in choosing which expert evaluation to accept? Did the court do what it shouldn't do necessarily, which is divide the expert values in half and say, oh, you're worth 800,000, you're worth $1 million, I'm going to call it 900,000 just to be on the safe side. Or did the court go ahead and combine years of income, okay, and say, listen, we're going to make your child support based upon, your current income, but in the years before you didn't have those raises, and that's a legal issue. You can't go ahead and average out income. Income can't be averaged out. Income has to be determined on a year-by-year basis for child support and alimony and things of that sort. So it depends upon the issue. Everything in an appeals is issue sensitive.
Yeah, that makes sense. I could see that, especially because there's so many different types of issues that can be appealed.
Yes. And one of the most interesting things about New York is in terms of family law is in Supreme Court, you have the ability to appeal interim orders. In family court, you can only appeal a final order as a matter of right. And if you can't, and if it's an interim order, you have to seek leave to appeal, which is very hard to get. So when it comes down to interim custody orders or visitation orders, in Supreme Court, they're appealable as a matter of right. In family court, they're not. So you seek leave to appeal. But the courts don't necessarily want to hear it.
Okay. What are some of the examples of issues that appellate courts commonly evaluate in custody or financial determinations?
Commonly, custody, visitation, or access, all the monetary issues, child support, alimony / maintenance, counsel fee awards, whether or not they're punitive in nature. You can't award counsel fees just because you don't like the person. You have to have a basis for it. You have to have a rationale for it. You have to have a disparity in income between the parties. And what I see is a lot of times lawyers are billing out more than cases are worth. So you have to watch that as well. Even if a guy's making $3, $4, $5 million a year, if the law firm on the other side goes ahead and bills out, and they have assets, let's say, of $10 million, and they bill out $15 million on the case, and I'm making these numbers up, they're all just hypothetical. But again, you're spending more on the lawyers than you actually have the case being worth. So would that be an abuse of discretion for the judge to award counsel fees in a very large amount when the case doesn't justify it, which is why legal fees have to be necessary or reasonable, actually not necessary, but reasonable in nature for giving the circumstances.
Okay. How does the standard of review influence what an appellate can realistically challenge in a family law case?
It's very difficult to challenge abuses of discretion. And that's when a judge is making a decision based upon not a legal principle, but based upon a factual principle. Because then judges have a lot of discretion. Who do I believe? Who don't I believe?
Right.
Why I believe them? Why I don't believe them? Custody and visitation issues, always abuse of discretion. Does the record support the judge's finding? If it doesn't, then you have an abuse of discretion. If it does, you're out of luck.
I know timing obviously matters in appeals. Are there deadlines or procedural requirements in New York that might often catch people off guard that you'd like to warn people about?
Sure. You have what's called notice of entry in Supreme Court. You have 30 days to file your notice of appeal from notice of entry. That's a very important date to keep track of. If there is no notice of entry, which a lot of lawyers thankfully don't send out, okay, then your time to appeal doesn't start to run. So you could theoretically go years or months without having to worry about actually filing your appeal. In family court, it starts to run from the time they mail you the order or provide you the order. There's no notice of entry. So you got to rush and file that appeal as soon as possible.
Okay, that's good. That's good to know. So family court's a little bit more, got to be more on top of it a little bit.
Yes. In the sense of appeals, yes.
Yeah.
Because once that order is mailed out, once that order is sent to you, once you're given that order, you got to get ready for that appeal.
What tends to shift in your strategy when you move from trial advocacy to appellate advocacy?
The shift in strategy is one of presenting law and facts. Okay. It's what's referred to in law school as IRAC, issue, reason, analysis, conclusion. What went wrong in the trial court? Why didn't the trial court find for your client? And you have to put that together. What are the issues? What are the reasons that they got wrong? What are the issues that were presented? what reasons did the court present for their reasoning, okay, and then how the conclusion was wrong. Okay. In trial strategy, you're very, very broad. You're trying to present as much as possible without helping the other side at the same time. So you're trying to curtail your testimony in some ways and expand it in others and be very self-serving in nature.
Do appeals really meaningfully change the direction of a family law matter as a general rule, or is it generally appealing smaller parts of the ruling?
It could be either or. When you're dealing with certain cases, judges, for one reason or another, don't like you. They just don't want to find for you. You're a nasty person. Okay, a judge decides, listen, you were a bum and didn't deserve 50% of the assets and gave you 25% of the assets. You're certainly going to appeal.
Yeah. What's the defense for the judge thinks I'm a bum?
Well, you didn't meaningfully participate in the economics of the marriage.
Right.
I mean, or you were highly abusive, or, you sat around playing Xbox while your wife went out and worked from 8 a.m. till 9 p.m. And at the same time, she took time off from her work schedule to take care of the kids because you were too busy playing Xbox.
Mm-hmm. Hey, Fortnite's not going to play itself, Yoni.
No, it's not. I understand that. And that may be a good defense.
For someone that might be listening to this and considering an appeal, what factors should they evaluate before deciding whether it really is a prudent step in their case?
They should always file the notice of appeal if they intend on perfecting. And if they're in family court, okay, they should definitely file the notice of appeal as quickly as possible if they feel they were wrong. Because you're not going to be able to get the transcripts in time. You're not going to be able to get the other documents in time. And while, let's say, in the second department, which is, Brooklyn, Queens, Nassau, Suffolk, okay, you have 6 months to perfect your appeal, plus extensions. Okay, so if you've got 6 months to perfect, but you only have 30 days to file, you're better off filing.
Mm-hmm.
It's already a final order in family court. Therefore, there's no risk of being stuck with it. In Supreme Court, it's a little bit different. You can get transcripts faster. You can get the decision faster. You can appeal faster. So you have the ability to work with that. And then you could evaluate the record before appealing.
Okay.
Because you will be stuck with the appeal. I mean,
Right.
Once you file, you're stuck with the fact that you didn't perfect it. And if you didn't perfect it, you may be stuck with the end result of what the first order was or how the first order was written, if it's an interim appeal.
And now you've just spent more money for nothing.
Pretty much, yes.
Yeah.
Yes, it's a problem.
So to make sure you know that you're going in with your eyes open and make sure you're doing the right. You've got the evidence to support your claim.
Yes, absolutely.
Okay. Makes sense. All right. Well, thanks for joining us today on Law and Life, the Leverance Approach. To contact Yoni and learn more, visit leverettslaw.com. And for more insights on navigating divorce and family law in New York, don't forget to subscribe to the show so you don't miss any future episodes. Yoni, I love chatting with you every time we meet. Thanks so much.
Thank you for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.